Hello everyone, I'm George from Ireland. So welcome to my English law channel, and here I'm looking at terms of a contract. So after this lecture, hopefully you should be able to tell apart terms from representations, and you will be able to explain how terms can be implied into a commercial or a consumer contract, especially pursuant to the Sale of Goods Act 1979 or the Supply of Goods and Services Act 1982. Further, you shall be able to tell apart conditions, warranties, and intermediate terms. Moreover, you will be able to apply your knowledge of the contractual terms to a real-life situation. So you'll be developing some professional skills here. You'll be able to moot on such issues later on, and you'll be able to deploy your legal lexis in one of these situations. This is going to hone your analytical skills, such you'll be able to deal with client issues that they bring to you. Anyway, you might also realize whether a few lacunae in your knowledge. Remember, teamwork is important in legal practice. Different solicitors and barristers working with each other, being able to speak to their client, whether he or she is a claimant or a defendant, and so on. All right, so if somebody purchased something in a contract, we have to be clear what thing he or she is buying, which item or indeed which service he or she is hiring. If they are buying an item, supposing it was a car, okay, you want to buy a car, but you said which make of car you want, all right? We also need to do which model of car you want. The year of manufacture might be relevant, the colour might be relevant or not, and so forth. Might have to be clear whether it's brand new or whether it's second hand, or indeed if it's second hand, is it really fifth hand or what? Or does that not matter? The fact that it's used or is all they need to know. So other things, are there any defects to its finish and so forth? And remember that it's got to be usable for the purpose for which it was purchased. And then the little things about when it's bought. Does it have a full tank of petrol or not? Do we need to know that are the brakes in good working order, or is that up, or is it a case of caveat emptor, buyer beware? So all that should be set out in the contract, but then some of that is implied terms. Remember that Harrow car sales case from 1956, car sales spelt with a K as one word, Harrow car sales, when the car salesman, he sold someone an automobile, but it turned out it didn't have an engine. But so, of course, a claim was put out about that. Anyway, the purchaser won his case. The court ruled that what was sold was actually not a car, since it was an implied term that it must have an engine, because without an engine it cannot be used for the purpose for which anyone buys a car, which is to drive it. So it was undrivable. So when you're considering these cases, you've got to first of all ask, is there a contract at all? Right? Did they agree to the same? Does this person have capacity to agree to such a case, such a contract? Because is he or she an adult? Even if so, is this person compos mentis? And so forth. If it is a proper contract, obviously the Sale of Goods or the Supply of Services Act will operate, and there's no bilateral mistake, that kind of thing. We have to see that we have the terms of the contract there, that these are reasonably clear, the various express terms, there are the implied terms, find out what's a representation, what was said when somebody was selling something, and what are these representations, misrepresentations, fraudulent representation, a negligent misrepresentation, perhaps an innocent misrepresentation, or a mere puff, of puff being just sales talk. If I'm selling somebody a suit, I say, ooh, looks good on you, sir. Or Heineken, Carlsberg, probably the best lager in the world. Okay, that's advertising speak. It's not something which is really provable one way or the other. Even an opinion could be a misrepresentation if there is no reasonable basis for opining so. Then, is there a breach of contract? And if so, what was breached? Was it condition? Was it a warranty? Was it in a nominate term? Because the remedies for these different breaches are all different. Are there exemption clauses? Will these exemption clauses operate? Because don't forget, exemption clauses will be regarded as invalid if they attempt to exempt liability for death or personal injury. Remembering, personal injury means injury to the body as opposed to injury to an inanimate object. Injury can mean damaging something like a book, a bicycle, a wall, any non-living thing. That also means there's also injury. So if you purchased a car, I would say, well, I want a let me see, Fiat Uno. Doesn't matter if it's white, such as a scene at the death of Princess Diana, or blue. And if it was blue, would it make a difference if it was midnight blue or navy blue? These are almost the same. If you ordered navy blue and you got midnight blue, would that be a sufficient reason to say, no, I didn't get what I asked for, therefore it's breach of condition? Maybe not. So anyway, so we look at the Sale of Goods Act. Section 12 talks about title. It's an implied term that the vendor has legal title to sell on. Remember, you cannot pass on a better title than you have. If the vendor doesn't have legal title, then the purchaser doesn't either. Section 13.1, description. If it's sale by description, then the item sold must be as described. But remember, sale by description is when the buyer doesn't actually get to see it and inspect it himself. Online sales are sales by description, even if you see a photo, because you didn't see it with your own eyes in reality. You're not dealing inter praesentes. Whereas if it was sold by inspection, you see it right in front of you. You maybe even have the chance to handle it. That's not a sale by description. Satisfactory quality. As per section 14.2 of the Sale of Goods Act, all items sold must be of satisfactory quality. That's an implied term. Satisfactory is not perfect, nor is it superb, but it cannot be bad. Section 14.3, fitness for the particular purpose for which it is bought. Now that rather overlaps with section 14.2. It must be capable of being utilized for the reason that someone bought it. And section 15, by sample. If someone gives you a sample of the thing, a free sample, then the main item you could purchase must be consonant with that sample. The sample mustn't be misleading. The Supply of Goods and Services Act 1982, section 13 says anybody selling a good or a service must exercise all reasonable care and skill. So you must be fairly diligent in what they do. Again, they don't have to be faultless. They don't have to be brilliant, but they cannot be bad. Okay, so remember, if there's any breach of contract, we've got to determine whether that was a breach of a condition, a warranty, or an nominate term. A condition obviously giving the right to terminate the contract. A nominate term breach of a warranty only gives the right to seek damages. If it's in a nominate term, as per the Hong Kong fur case, it depends what the repercussions of that breach are. Now, it could be, even if it's a breach of a condition, the breach is so trifling that wouldn't give rise to the right to rescind the contract. Remember, de minimis non curat lex. The law doesn't care about the smallest things. Okay, so we've got to see what the terms were and whether it was an express term which is actually written into the contract, and whether something was a term or representation being something that was said in the course of negotiations, possibly not written into the contract, could be considered part of a collateral contract. And if so, was this term or representation breached? You can rescind for misrepresentation in some cases. And don't forget that the consequences of rescinding for breach or rescinding for misrepresentation are different. So it's very important we are clear about what ground somebody is rescinding for. Or was there a breach of a condition? Remember, conditions go to the root of the contract. If you asked to buy a car, you're given a motorcycle, that would clearly be a breach of condition. Or indeed you wanted that white Fiat Uno, you asked for a Fiat car and you got a Ford car, for instance. You wanted a 5-seater, you got a 4-seater, and so forth. A breach of a warranty, as in we said this car will last at least 2 years, and now you're saying it'll only last 1 year. or an innominate term, which is neither a condition or a warranty. So to come back to representation, we have to bear in mind how important this representation was, or this statement was. The more important it was, the more likely it is to be representation. Think about expertise. The more knowledge that the representor had, the more likely it was to be a representation. If both parties have an equal level of knowledge, it probably wasn't a representation. If one car dealer is selling to another car dealer, it probably wasn't a representation because they have an equal level of knowledge. And the timing is also relevant. Thinking about implied terms, if you believe there's a breach of an implied term, which act is it breaching, and which section of which act is it breaching? Are you sure there's a breach? Was it the breach of a condition, or a warranty, or possibly an innominate term? Remember, innominate term is also called an intermediate term. So the Sale of Goods Act is always pertinent to alleged breaches of this implied term of the quality being satisfactory. Anyway, so if you sell something and say, this car will make you really attracted to the opposite sex, I think that's a mere puff. That's not something which is justiciable. If you're buying a piece of equipment that needs to be installed, does the seller have to install it or not? What if the contract is silent on that? I don't think it's not implied into a contract. The seller does have to install it. Okay, so I don't think it's an implied term that it will be installed like that. Anyway, that's just a little bit about the Sale of Goods Act and implied terms. Toodaloo.